What is the doctrine of harmonious construction? One meaning of harmony is a state of being in agreement. The doctrine says that a provision of a statute should not be interpreted in isolation. Any provision should be interpreted as a part of the entire statute so that any conflicts or inconsistencies are removed. For example, if one part of the statute says that citizens can walk their dogs in the park at any time, but another part says that animals are not allowed in the park between 6 p.m. to 6 a.m., then the two provisions seem to be contradicting each other. Either of the statutes, when read in isolation, will cancel out the other. This doctrine says that one provision should not be allowed to defeat or cancel another provision, unless there is no reasonable option. So, a harmonious interpretation could be that citizens can walk their dogs in the park at any time except between 6 p.m. to 6 a.m. Venkatramana Devaru versus State of Mysore, Unni Krishnan versus State of Andhra Pradesh, and State of Rajasthan versus Gopi Kishan Sen are some of the landmark cases where this doctrine was used. What is the doctrine of incidental or ancillary powers? Incidental means something that is less important than the thing it is connected with or part of, such as seat covers are incidental to a car. Ancillary means providing additional support or help, such as volunteers supporting the traffic police. The doctrine grants the government the ability to use incidental or ancillary powers, which are not explicitly mentioned in the Constitution or in a law, as long as those implicit powers are necessary to exercise the constitutionally granted powers. In simple words, if the law just gives an axe, then the handle is incidental and ancillary, even if it is not specifically mentioned. The various subjects that the governments can legislate on are given in the 7th schedule. While regulating social media may not be specifically mentioned, it is an essential part of regulating communication. So, the government uses incidental and ancillary powers to regulate social media. United Provinces versus Atika Begum, State of Rajasthan versus G. Chawla, and RMDC versus State of Mysore are some of the landmark cases where this doctrine was used. What is the doctrine of waiver? Waiver is the act of intentionally giving up or abandoning a right, claim, or privilege. For example, if I find someone else sitting in my seat in a theatre, I may enforce my right to sit in that seat, or I can choose to waive my right and sit somewhere else. This waiver can be explicit or implicit. If I waive my rights intentionally, then I cannot subsequently try to enforce them. For example, if I waive my right to receive rent from my tenant by a specific date, then I cannot subsequently impose a penalty on the tenant for being late. While most rights can be waived by the holder, the Supreme Court has frequently held that fundamental rights cannot be waived, especially since they are a matter of public policy. Baseshwar Nath versus the Commissioner of Income Tax, Olga Tellis versus BMC, and Jaswant Singh Matra Singh versus AMC are some of the landmark cases where this doctrine was invoked. What is the doctrine of judicial review? This doctrine means that the actions of the government are subject to judicial review. Judicial review is considered as a part of the basic structure of the Constitution. Several articles of the Constitution specifically provide for judicial review as a part of the checks and balances design, so that no branch of the government can act without oversight. Primarily, government actions are reviewed to ensure conformance with the Constitution. The court can check for violation of fundamental rights, violation of any other articles or statutes, exercise of powers that the government does not have, misuse of powers, or any misunderstandings or misinterpretation. The review also covers procedural propriety, reasonableness, legitimate expectation, erroneous jurisdiction, and natural justice principles. The A.K. Gopalan case, the Sajjan Singh case, and the Minerva Mills case are some of the landmark cases where this doctrine was used. What is the doctrine of Parens patriae? Parens patriae is a Latin term meaning parent of the country. This doctrine holds that the state has the duty and the power to provide care to its citizens who are unable to take care of themselves. The state provides protection to the person and the property of those who are unable to take care of themselves, such as citizens who are minor, insane, incompetent, or disabled. This doctrine is derived from the Constitution. The preamble and the directive principles of state policy mandate that the state must promote the social, economic, and political welfare of the people. In 2020, the Punjab and Haryana High Court declared Sukna Lake to be a living entity and invoked the doctrine of Parens patriae to direct protective measures. And in 2022, the Madras High Court declared Mother Nature to be a living entity and invoked the powers of Parens patriae. What is the doctrine of repugnancy? In the legal context, a simple definition of the word repugnancy is inconsistency or incompatibility. If there are two laws, one says parking is allowed and the other says parking is not allowed. If both are valid laws, following one law means violating the other. This is a situation of repugnancy. The concurrent list has subjects on which both the state and center can legislate. If a law enacted by the central government on a concurrent list subject conflicts with a law by the state government on the same subject, which one will prevail? Article 254 deals with inconsistency between laws made by the parliament and laws made by the legislatures of the states. This article is the basis of the doctrine of repugnancy. If a state law and a central law on a concurrent subject are in conflict, then the central law will prevail, unless the President of India has given his assent that the state law shall prevail in that state. M. Karunanidhi versus Union of India, Hext Pharma versus State of Bihar, and Government of AP versus JB Educational Society are some of the landmark cases for this doctrine. What is the doctrine of res judicata? Res judicata means a matter already judged. This refers to a matter that has been decided or settled on its merits by a court that has the competent jurisdiction, and the same matter cannot again be subject to litigation between the same parties. For example, if A and B are claiming a property and B files a suit in a court, the court rules in favor of A. B cannot again file the same claim against A in the same court. Res judicata does not stop B from appealing against the decision in a higher court. It also does not stop any other person from pursuing a similar claim, as long as that person was not party to the originally decided case. The reason behind this doctrine is to stop endless litigation. Otherwise, nothing will ever get settled. Section 11 of the Civil Procedure Code is based on this doctrine. Gulabchand Parikh versus State of Bombay, Dario versus State of UP, and State of UP versus Nawab Hussain are some landmark cases for res judicata. What is the doctrine of necessity? It is a legal principle that justifies the violation of the law in cases of emergency or necessity. This doctrine is applied in unavoidable situations in both civil and criminal law. Section 81 of the IPC says that any act that is done without any criminal intention and in good faith for the purpose of preventing or avoiding another greater harm is not an offense. For example, it is not an offense if a train driver diverts to a different track and knowingly causes the death of one person to avoid an even bigger accident. The doctrine of necessity is also used as an exception against the principle that no person should be a judge in their own case, if it can be proven that there was no other choice. The basic principles for application of this doctrine are imminent need or threat, proportionality, and no other choice. Gullapalli Nageshwar Rao versus APSRTC, ADM Jabalpur versus Shivkant Shukla, and Tata Sillar versus Union of India are some landmark cases. What is the doctrine of pleasure? The phrases during the pleasure of the president or during the pleasure of the governor appear several times in the constitution. According to this doctrine, individuals who are appointed at the pleasure of the president or the governor of a state can be removed by the appointer at any time, without notice and without having to provide any reason. In short, the government can appoint and also dismiss its employees at any time without giving any reason. And if proper procedures are followed, the government's actions cannot be challenged in a court. Article 310 of the Constitution confers the power that can be exercised under the doctrine of pleasure. However, this power is not absolute. There are some restrictions, limitations, or safeguards, such as under Articles 311 and 14, which protect the rights of the employees against arbitrary actions. Mohinder Singh Gill versus CEC of India, State of Kerala versus Thomas, and Naresh Chandra Mishra versus State of Bihar are some landmark cases for this doctrine. What is the doctrine of constitutional morality? Morality refers to the values and principles that distinguish between right and wrong or good and bad. Morals cannot be compulsorily enforced. They are voluntary. If a moral is compulsorily enforced, it becomes a law. For example, in a crowded metro, if you offer your seat to a senior citizen voluntarily, you are following your moral principles. If you are forced to give up your seat, since some seats are reserved for senior citizens, then you are following a law. Constitutional morality refers to the moral principles and values that are enshrined in the Constitution that the government and the citizens should follow, not only in letter but also in spirit. For example, adhering to the laws regarding equality is mandatory, but going above and beyond the law and ensuring equality in true spirit is morality. Rule of law, equality, social justice, liberty, and freedom of expression are some of the aspects of constitutional morality. Nas Foundation versus Government of Delhi, Navtej Singh Johar versus Union of India, and the Sabarimala case are some landmark cases for this doctrine.